Hey everyone, I'm Matt with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about civil protection orders. So, the rules surrounding them, the statutes that govern them, and then the actual forms that you have to fill out and how the process works. So, to get into it, I'm going to share my screen and show you the relevant statute. So, it's Connecticut's General Statute, Section 46B-16A. And what that says is that any person who has been the victim of sexual abuse, sexual assault, or stalking may make an application to the Superior Court for relief under this section. And I'll get into the definitions of sexual abuse, sexual assault, and stalking. So you can apply for a civil protection order provided that you have not obtained a court order of protection arising out of the abuse, assault, or stalking that you're claiming. So if you've already filed a restraining order in family court, or if there's been an arrest and there's a criminal protective order in place because of the specific abuse or stalking that you're referencing in this application, if there's already an order in place, then you wouldn't qualify for a separate civil protection order. And you also don't qualify if you would otherwise qualify to seek relief under 46B-15, which is the family restraining order statute. So there's a separate video on how to file a restraining order, and it talks about who is eligible for a family restraining order. It's basically household members, or, so it's like a roommate, somebody who you've lived with in the past, a family member, somebody you've dated in the past, things like that. And the civil protection order form actually lists all of the people who qualify as family or household members under 46B-15. So I'll get into that in a minute when we're going over that form. So if you've been the victim of sexual abuse or sexual assault, I'm not going to get into those definitions. They're somewhat self-explanatory, but stalking is a little bit more murky, and it defines stalking as two or more willful acts which are performed in a threatening, predatory, or disturbing manner of harassing, following, lying in wait for, surveilling, monitoring, or sending unwanted gifts or messages to another person directly, indirectly, or through a third person by any method, device, or other means that causes such person to reasonably fear for his or her physical safety. So that's the definition of stalking. It's obviously very broad, and many different behaviors would fall into that definition. So if you meet the requirements of this section that I've highlighted here, you can potentially qualify for a civil protection order, which would basically what it does from a practical standpoint is it puts a court order in place that tells the other person they can't bother you, they can't talk to you, they can't come near their house. I mean, a judge could put various restrictions on the person who you're asking to be protected from. And then if the person violates those restrictions that the court puts in place, then they are subject to arrest. So that's the relevant statute. And then let's just go over the form briefly. So this is JD-CV-143. And if you just do a Google search for this form, you can find it. So a lot of the forms I put on our website, but I don't want to put this on our website just because the courts periodically update the forms. So if you're watching this, I don't want you to use an outdated form from our website. But, so just do a Google search, and then you're just going to fill in the judicial district. And then just so you know, you can call our office certainly for help filling out these forms if you want to hire an attorney. But if you go to the courthouse, there should be people there who can kind of answer questions you have about the forms. But this video will hopefully be a good start. So you're going to put the judicial district where you're filing the protection order, the court location. You leave the docket number blank. There is no docket number if you're filing this. The court will fill that out. And then if you're the applicant, you're going to put your last, first, and middle initial, date of birth, your sex, your race, your mailing address, your mailing address, your home address, if that's different than your mailing address, and then your work address, if that's different from your mailing address. Or I guess you have to put your work address no matter what, if you have a work address. Obviously, if you don't have one, you can leave that blank. And then if you're a minor, you're going to want to put the name of a next friend. So basically an adult who can be involved with you in this process. So, and then just so you know, if you don't want to disclose your address, this paragraph talks about the fact that you can fill out this form JD-CV 163 if you want to ask the court's permission to not disclose your address. Then you're also going to put the information of the respondent. So that's the person you're asking to be protected from. You're going to put their name, date of birth, all of their basic information to the extent that you know their information. Whether or not you know them, and if you do know them, how you know them. And then again, if the respondent is a member of your family or household, you basically don't qualify for a restraining order. So if any of these things apply, you don't qualify for a protection order. If any of these things apply, then watch the video that I did on restraining orders. You would want to file a restraining order rather than a civil protection order. So, you're going to check off the no box here if you want to apply for this. If there are any criminal protective orders or family restraining orders that, it might be from a separate incident, but if there are any protective orders or restraining orders that you know of, check this box and put the docket number and court location. Then again, put the name of the applicant, respondent. Docket number can stay blank. Then you're going to check off if if it's a claim of sexual abuse, sexual assault, or stalking. You're going to need to check off that you have not obtained any other court order because of this incident, that they're not a member of the family. And then what you're asking for. So, pretty much you're always going to be asking that they not assault, threaten, abuse, harass, follow, interfere with, or stalk you. Probably want them to stay away from your house. Probably don't want them to contact you or be within 100 yards of you. So you're probably going to want to check all these boxes off, but you may have some reason for not checking them off, in which case you can leave it blank. And then you can ask for some additional relief here. If you're in, if you're in school and you want a copy sent to your school, you can fill out that information. And then if you're asking, check here if you're asking for immediate relief. So basically how it works is when you file these things, the court can do a couple of different things. They can just deny it. If they find that you haven't met the threshold of, sexual assault, abuse, stalking, they can just deny it, and that's the end. You don't get to do anything else. But if they don't deny it, they can do one of two things. They can either grant ex parte relief. So basically they can grant immediate relief and grant your restraining order. There's an immediate order that says that the respondent can't, threaten or harass or stalk you, or they can't be within 100 yards of your house, etc. They could grant that, and then they have to schedule a hearing within 14 days of you filing this application. But they might not, they might be so-so on whether they're going to grant the restraining order, or they just might not be sure, or they might not think that there's a need to put any immediate relief into place, in which case the court can not enter any immediate relief, but still schedule a hearing for 14 days later to hear more and whether they think a restraining order should be granted. So if you're asking for immediate relief, which you probably are, you're going to check off this box here. And then you're going to, sign the form, wait until you're at the clerk's office before you sign it. And then if this is just a firearm section. So if you know anything about whether or not the respondent has firearms, just answer these questions. So that is the application, and then you have to fill out an affidavit to support it. So you're going to put your name, the respondent's name, the name of next friend if there is one. Again, you leave the docket number blank, And then you're going to want to just write a narrative here about why it is that you're asking for the protection order to be put in place. So you want to, you want to be specific about dates. So you want to show that it's recent, you want to set the time frame, and then you want to, explain in as much detail as possible how the person sexually abused you, how the person sexually assaulted you, how the person stalked you. And just be careful, when you're filling it in, just, be mindful of the definition. So, don't, if it was just one incident of stalking, you're probably not going to qualify because it has to be 2 or more willful acts. So just be mindful of the definitions when you're filling out this application. So that's pretty much it on the forms. So again, procedurally how it works, if you're going to file this application, you're going to submit it to the court, and then they're either going to deny it, in which case you don't have to do anything else, or they're going to grant it either ex parte or schedule a hearing. But if they do grant it in any capacity, there's going to be a hearing within 14 days. And then, once you have that hearing scheduled, you're going to get paperwork back from the clerk's office, and then you have to make arrangements for the respondent to be served by a marshal. So that's basically an official person from the state of Connecticut who's going to show up at the residence of where this person lives, or somehow track them down and serve them with the paperwork so that they have notice of the hearing. So there, with these civil protection orders, the court should put you in contact with marshals who kind of are around the courthouse, and they should serve the respondent for no fee. There shouldn't be any charge for that. So you got to make sure you get the respondent served, and then on your court date, you're presumably going to appear in front of, you'll show up for court, you're going to appear in front of the judge. The applicant will speak first about, what happened, why they want the protection order to be put in place. Then the respondent will have an opportunity to cross-examine the applicant, so ask questions to try to poke holes in their story. And then the respondent will have an opportunity to give their side of the story, with the applicant having the ability to cross-examine them. And then, you can call witnesses, you can bring other witnesses with you, etc. That we should have some other videos that talk about direct examination, cross-examination, things like that. So that is pretty much it. The court has the ability to grant these civil protection orders for up to 1 year. That's the maximum. They could say 6 months, they could say 3 months, they could just deny it outright. But if they do put it in place for a year, for example, you do have the ability to come back, near the expiration of that year and ask that it be extended. But initially, and then the court can extend it up to 1 year beyond that. So, and then you have to renew it every year, basically. But the court can't say this is in place for a lifetime. The maximum they can put it in place is for 1 year, and then that is subject to renewal. So those are the basics on civil protection orders here in Connecticut. As always, if you have any questions, feel free to give our office a call, and we'd be happy to help.